Okay, I think we are ready to start. Okay, so good morning, good afternoon, good evening. Welcome to the International Workshop on Arctic Ocean Governance and the Law of the Sea. My name is Kentaro Nishimoto, Professor of International Law at the National Institute of Polar Research and Tohoku University in Japan. This workshop is convened by the International Law Research Program of the Arctic Challenge for Sustainability 2, or ArCS2 project. ArCS2 is a national flagship project in Japan for Arctic research. On behalf of the conveners, I would like to thank all of the panelists and also the participants for joining us in this event. The Arctic Ocean continues to undergo a very rapid transformation due to climate change and the increase of anthropogenic activities. And we also see significant changes in the geopolitical conditions. And so we intended this workshop as a forum to exchange ideas on various new and also persistent issues regarding the governance of the Arctic Ocean from the perspective of international law. For today, we have two sessions planned with a keynote presentation and 4 presentations. So now, without further ado, I would like to open the first session. And we begin the first session with a keynote presentation by Professor Suzanne Lalonde, who is a professor of international law at the University of Montreal. The topic of the presentation is the increasingly entangled Arctic continental shelf process. Professor Lalonde, you have the floor.
Thank you so very much. I hope everyone can hear me and can see my screen. Good. My sincere thanks to Professor Nishimoto for the opportunity to participate in this important workshop. And thank you also to those of you who are participating at an inconvenient or late hour. It is very much appreciated. As any international legal scholar, I believe in the adherence to the rule of law because it brings stability through predictability of behavior and of outcomes. And so in this light, I'm keenly interested in the role that legal rules play in resolving sensitive boundary issues. I do worry, though, at times, perhaps too much store is put in the law, and I'd like to take a few minutes to talk about that. I need to just, sorry. All right. So in 2008, the Ilulissat, went a bit too far. The Ilulissat Declaration helped to dissipate the media-fueled perception of a crisis in the Arctic region, because the declaration contained a very strong commitment by the A5, a recognition that the existing international legal framework provides a firm basis for the handling of any Arctic Ocean issues, and that the Arctic coastal states will settle their disagreements peacefully and in accordance with this existing legal framework. But one of the examples cited in this important third paragraph, which I've reproduced, gives me some pause. The reference to the delineation of the outer limits of the continental shelf. And in the last sentence, as you can see, the commitment to the legal framework is reaffirmed and reference is made specifically to the orderly settlement of any possible overlapping claims. A direct reference, I would suggest, to the delineation and delimitation of the continental shelf. I think the continental shelf in the Arctic context perfectly illustrates that the law can only go so far, that political commitment or buy-in or political goodwill is also crucial. So I think the continental shelf, the way the issue has played out in the Arctic, is a very instructive case in point. As we know, delineation refers to the drawing of a line between the continental shelf and the area and is governed by Article 76 of the Convention, which triggers the Commission process. The Commission on the Limits of the Continental Shelf plays a very important role, verifying whether a state submission complies with the substantive and procedural terms of Article 76. Delimitation, on the other hand, refers to the establishment of maritime boundaries between the continental shelf of adjacent or opposite coastal states and is governed by Article 83 of the LOSC. And according to Article 83, it is for the neighboring states themselves to agree on those boundaries with the aim of achieving an equitable solution. As Bjarni Magnusson has written, the law of the sea convention creates a firewall between the delineation and the delimitation of the continental shelf. Article 76, paragraph 10 clearly states that the commission process does not prejudice the question of the delimitation of the continental shelf between states with opposite or adjacent coasts. And this important constraint is repeated in Article 9 of Annex 2. The actions of the commission do not prejudice matters relating to the delimitation of boundaries between states with opposite or adjacent coasts. Unfortunately, the commission itself has breached that firewall, has thrown that firewall to the ground. Paragraph 5A of Annex 1 of the Commission's Rules of Procedures declares that where a land or a maritime boundary dispute exists, the Commission will not consider and qualify a submission made by any of the states concerned. Now, as Vladimir Jarez reminded me recently, Annex 1 and this paragraph was discussed and approved by the 8th meeting of the parties. I think that rule at paragraph 5A is to be deeply regretted. And in talking with Vladimir, I think a number of states now realize perhaps it was a mistake and they should have trusted in the protection afforded by Article 76, paragraph 10 and Article 9 of Annex 2. For as Coulter Lapthrop and Andrew Surdy explain in those quotes, paragraph 5A gives other states a veto simply by notifying a dispute. Such a notification effectively blocks the Commission's consideration of their neighbor's submission. But in the Arctic, there has been, well, at least to date, a commitment not only to the general legal framework, but there has also been faith in the actual rules. The A5, thus far, have allowed the legal process set out in Article 76 to unfold. As provided in the last sentence of this paragraph 5A, they have consented to let the Commission do its work, to study their neighbor's scientific dossier and even to make recommendations. But knowing and understanding that those recommendations cannot prejudice the delimitation of their maritime boundaries. Canada's 2019 partial submission in regards to the Arctic documents in the executive summary this very real manifestation of the A5's commitment to the international legal framework, but more than that, also a level of political collaboration. And you have here, this is just, I gave the paragraph on the Kingdom of Denmark, how, you know, the two parties had reached an understanding. And then there's also references to a similar agreement with Russia and even with the United States. Because as this audience will know very well, in other parts of the world, coastal states have exercised that veto power described by Andrew Surdy and Coulter Lapthrop. And this is just a few examples. And as you know, we have cases where neighbors just instantly object to each other's submission. Lest I give you the impression that the Arctic states are a bunch of altruistic, like selfless bunch of states, I should say that this collaborative spirit has been under a certain strain, I would say, recently, particularly in recent weeks. There seems to be a kind of tit for tat game going on, or one of one-upmanship, which the Merriam-Webster dictionary described as the art or the practice of outdoing or keeping one jump ahead of a friend or a competitor. On the 31st of March, 2021, the Russian Federation submitted 2 addenda to its 2015 partial revised submission in respect of the Arctic Ocean. The accompanying official maps refer to Canada's 2019 partial submission. And at page 6, that line that I've reproduced, the executive summary confirms that the Russian outer limit of the continental shelf line now extends to the EEZ of Denmark and Canada. And the darker green colors on this map illustrate the areas of continental shelf added with the 2021 addenda. Then, I mean, a total surprise, no warning, no fanfare. This past 19th of December, just a couple of months ago, Canada submitted its own addendum to its 2019 partial submission in respect of the Arctic Ocean. The accompanying maps, and you have them top and bottom, so the most recent is at the bottom, show how Canada's claim now stretches along the Lomonosov Ridge all the way to abut with Russia's EEZ. According to an Arctic Today article published on the 21st of December, a conservative estimate is that Canada has extended its claim by some 600,000 to 700,000 square kilometers. There hasn't been very much coverage of this addendum in Canadian media, but what coverage there has been around this revised Canadian submission seems to want to stress that consultations were held with Russia before, submitting this addendum. It may be, but I think the situation is perhaps a little bit more murky. This is the executive summary for this recent, a couple of weeks ago, this recent addendum. At pages 10 and 11, so there's a section of the executive summary that refers to, at some length, the non-objection agreements that Canada has with each of the other coastal states with which it has an overlap. And the longer section is on the Russian Federation, and it refers again to this non-objection agreement, this idea that both neighbors will let the Commission do its work and proceed with the consideration of each other's submissions. And the second paragraph, I tried to make it a little bit bigger. It's just that it recounts how this agreement was put, very much into action when Russia filed its partial revised submission in 2015, and also how it also came into action when Canada filed its partial submission in 2019. And you'll see that reference is made to diplomatic notes being sent to the Secretary General of the UN to that effect. But in the last two sentences, the document refers to Russia's actions in March of 2021, which it states modified the continental shelf overlap, and just concludes that the arrangement between the two countries remains applicable. Now, to state that the non-objection agreement is still applicable, I don't think is quite the same thing as to say that consultations were held with Russia. Now, don't get me wrong. I believe the agreement not to object still holds, but the strain in relations as a result of the Ukraine aggression, I think, are kind of apparent, are pretty apparent. Reaction from President Putin was pretty swift, and multiple media outlets reported that a few weeks ago, just in last January, President Putin held talks with members of the Security Council about Russia's efforts to expand the outer limits of its continental shelf in the Arctic Ocean. And then just this week, just this week on the 14th of February here, Russia submitted further information on the limits of its continental shelf in respect of the southeastern part there of the Eurasian Basin in the Arctic Ocean. At the moment, the executive summary is only available in Russian, but the map included with this summary seems to outline a slight expansion of the area claim. But this, you will say, is fantastic. Okay, a little odd, but still fantastic. All these revisions, an addenda, an extension, all of this supported by scientific data collected in line with Article 76 are being formally submitted to this CLCS process. Russia and Canada are playing by the rules. And I suppose, yes, of course, this is a good thing. And in any case, I don't think there is any more continental shelf that can be claimed at this point. But to get back to my earlier point, so the law, everyone's playing by the legal rules, except I would submit this is only half the game. Because as we have seen, the legal rules always provided that political or diplomatic processes will have to take over at some point. The so-called legal framework has always envisaged that it will be up to the states themselves to find a solution or a compromise. And those solutions or compromises, that might yield an equitable result, which is what Article 83 commands, well, those kind of solutions, they require a high level of significant collaboration and quite a bit of trust. And I think that it might be at this stage that the collaborative approach that has characterized the continental shelf process in the Arctic might break down, but perhaps not, but might. On this slide, I've just listed 4 possible options for resolving the delimitation of the, what might that look like? Well, of course, option 1, the states could wait until all of the concerned coastal states receive recommendations from the Commission to begin negotiations on their maritime boundaries. But will the Arctic states be willing to wait for decades? Because Canada is far, far back in the queue. But then again, perhaps time would allow for relations to warm up again. Option 2, refer the delimitation to an adjudicative body ahead of the Commission's recommendations. Now, I think there's zero appetite among all the Arctic states for adjudication. Option 3, conclude a delimitation treaty with the states concerned, again, ahead of the Commission's recommendations. This is, in fact, what Canada, Denmark, Greenland did last June when they resolved their dispute over Hans Island, but in the same agreement, fixed their continental shelf boundary beyond 200 nautical miles in the Labrador Sea. Now, by entering into a treaty or agreement like this to delimit their continental shelves, states, of course, cannot escape the consequences of the CLCS process. As the Commission established when it dealt with the joint submission of France, Ireland, Spain, and the UK in 2007, states cannot act in concert to include within their continental shelves areas to which none of them acting individually is entitled under Article 76. After all, 76 paragraph 10 reminds us that delimitation of an area of continental shelf beyond 200 nautical mile presupposes that there is an overlap of entitlements of the states concerned to that area. And I've just listed some of the issues around entering into those kinds of treaties. There is a slight risk that the submissions of the parties may result in recommendations to the effect that seabed or one or both sides of the boundary is outside the greatest possible extent of the continental shelf of the party concerned. So, and that this in turn might trigger the need for a difficult renegotiation of a treaty, or even might lead to a unilateral demand for such a renegotiation, citing, under the terms of Article 48, paragraph 1 of the Vienna Convention on the Law of Treaties. Maybe one of the states of the parties concerned would be able to say that, well, the treaty has ceased to be or never was binding as it was based on a shared factual error as to what were the primary overlapping entitlements to be delimited. I wonder, I'm not sure, I wonder if paragraph 2 of Article 48 might help resist such a kind of a unilateral demand to revise a treaty, saying that, you can invoke paragraph 1 because the state in question has contributed by its own conduct, perhaps to the error, or that party should have known of a possible error. But then again, as long as each part of the area delimited in that kind of a treaty is within the CLCS recommended outer limit of at least one of the parties, then the parties could agree, and that could be built into the agreement expressly or tacitly, that the treaty should be left as it is. The party whose continental shelf pursuant to the recommendation does not reach the negotiated boundary might nonetheless continue to exercise continental shelf rights there in that area, and that would be because those rights would be derived from the party which the CLCS has endorsed. This appears to have occurred in a small area on Australia's side of the boundary with New Zealand, which was submitted to the CLCS as part of the Macquarie Ridge region, but which was determined by the CLCS, this area, that the CLCS in the end did not recommend that it should form part of Australia's continental shelf. But thanks to the agreement, Australia does exercise rights up to the boundary. And I think it's a kind of a situation that leads to the type of similar areas that we've seen created by the 1990 United States-Russia Maritime Boundary Agreement in the Bering Sea and the 2010 Russian-Norwegian Maritime Boundary Treaty. There is also, and this is the last option, of course, there's also option number 4. Maybe what the parties could do, Canada, Russia, Denmark, Greenland, could enter into a provisional arrangement until they all received the Commission's recommendations and can then proceed with a final delimitation agreement. And of course, this is specifically provided in Article 83, paragraph 3, that in a spirit of understanding, cooperation, states should make every effort to enter into provisional arrangements of a practical nature. Of course, even the article stresses spirit of understanding and cooperation. And I find it's interesting, again, a reminder that these kinds of arrangements would not prejudice the final delimitation. Of course, and this is my last slide, there's all kinds of shapes and forms and content in that could be imagined in that kind of a provisional arrangement. I mean, the parties could simply agree to refrain from any exploitation activities in the contested or overlapped areas, something along the lines of the 2016 joint Canada-US moratorium on new oil and gas licenses in the Beaufort Sea for the Beaufort Sea in the contested area. A much more cooperation-intensive solution could be a joint development agreement for these areas of overlap, but I think a high level of trust is required in such cases, in such arrangements. It's quite difficult, can be difficult to manage. Or the provisional arrangement can set out a provisional maritime boundary. This option has played out, has been chosen by, for instance, the Faroe Islands, Iceland, and Norway in 2006, and also between Greenland and Ireland in 2013. But I would caution that such an agreement must explicitly provide a process or rules to adapt the provisional boundary to take into account the Commission's eventual recommendations, because, this provisional boundary line might be in place for decades and create maybe some expectations. So the provisional agreement must be pretty clear, very clear about what will occur eventually. In the end, it's impossible to predict how the tangled mess of overlapping continental shelf claims will eventually be resolved in the Arctic. But to date, the Arctic coastal states have been a very encouraging example of faith in the legal process and rules, and of political goodwill, even in the face of strained relations. Let's just hope they can stay the course. Thank you very much.
Thank you very much. I think it's indeed encouraging to see that the rule of law plays a very important role, even in the Arctic Ocean, where it's usually perceived as a rather difficult region. And it's rather refreshing, actually, to see that the process has prospects of moving forward, especially coming from a region where coastal states have been blocking each other's submissions. So when I began, I forgot to make some housekeeping announcements, and I just wanted to announce that we have reserved ample time for discussions. So if you have any questions, please input your questions in using the Q&A functions, and I think then we can take them up. So please input your questions using the Q&A function on the web on Zoom. Okay, so while we are waiting for some questions, I did have one question, and I wanted to ask whether you see any difficulties regarding the Arctic Ocean continental shelf if the situation was left as it is. So I think for all of the coastal states to receive a recommendation, I think you mentioned it will take quite a long time. Of course, we always have the question of what to do in the meantime. And I saw that you gave us very concrete ways forward in terms of managing the situation and leading to the final delimitation. But would you see any practical difficulties if states simply left the area as it is, pending the coastal states receiving recommendations, and then maybe starting to delimit the boundary based on the recommendations?
Yes, thank you for your question. I think so. It's just trying not to be too doom and gloom but so I was, to be perfectly honest, I'm from the outside, and I was interested to hear that the Canadian government had been discussing, that there had been this contact, because we've been told everything is pretty much frozen at the moment. But then wearing down into the executive summary, you realize I don't actually think there was close contact before Canada submitted this recent addendum. And I think that is the state of play. I think there's very little contact. And I think that makes me extremely nervous. As long as we talked, I think the very long delays could be managed. But I fear impatience if there's a real thought that there might be valuable resources or their self-interest could be served by proceeding in a sense unilaterally. I wonder, and if perhaps, what has brought the A5 together is anytime someone from the outside tries to push in, right? And, the reaction, and, the Ilulissat Declaration is so clear. We do not need a new Arctic treaty in direct reference to what was happening in the European Union at the time. So you see them fold in together. And I just wondered, it has been noticed that some third states out of the region states are interested, obviously, in the high seas areas, but not just the high seas areas, also any areas, any little sections of the area that may be there. And there's already scientific missions. And through the grapevine, unofficially, I heard that US officials weren't very happy that some scientific expeditions were occurring over what they consider will be Alaska's outer continental shelf. So a little bit of friction that, as long as things aren't settled, perhaps third parties might be feel, will continue to be very interested. So I wonder if that might be the trigger for collaboration, and apologies to parties outside the region, but that this might thaw and allow for some discussion. It's very difficult at the moment, though, very, very difficult.
Thank you so much. And I think we're starting to receive questions on the Q&A function for Zoom. And we have a question from Professor David van der Zwag asking any insight on future resolution regarding the Gacko Ridge. Would you care to address that question?
Well, I think what we're seeing, but I mean, I would say that Professor van der Zwag, it's a shame that if he can turn on, he would be the one to answer. I think what you're seeing is, I feel perhaps the most explicit defense of the fact of the use of the ridges as extended continental shelf. And I think I'm trying to say which of the addenda or addendums that, they're not subjected to the 350-mile constraint. So really, they are just natural components of the continental shelves. And in this case, the most recent activity, both Canada and Russia pushing for that interpretation. And I think that the Commission has some definite views, has offered some precision as to how to qualify some of these underwater features. So time will tell. I just think it is a little bit more, in French you say affiché. They're very much laying their cards on the table in terms of their interpretation, and certainly feel they can go for broke. But happy to exchange with Professor van der Zwag on that to see his thoughts.
Yes, I think I must apologize for this format. So we were expecting a fairly large number of participants, so we could not use sort of the normal Zoom conference where we can invite more active input from the participants.
Of course.
Yes. I see there is another rather general question from Lauren Fields asking, how do multilateral international agreements impact extended continental shelf claims?
How do you motivate?
How do multilateral international agreements impact extended continental shelf claims?
It would be interesting to know which type of multilateral agreements. I mean, I think in the early days, the one I mentioned, which was really quite a fascinating, if you think it was the one I mentioned, the four parties, I'm just looking for the, so 2007, France, Ireland, Spain, and the UK. That was a very interesting, and that was multilateral, 4 states, and talk about collaborative approach. Let's prepare a joint submission and tell the pool our research and explain to the Commission that we feel that the outer limits of our continental shelves, and 2007 was still fairly early in the work of the Commission, and so I think that's a really interesting example or case in the sense of a situation. And at the time, some commentators felt the Commission was a little harsh, but I think it needed perhaps to set the rules. No, by ganging up the 4 of you, you can't claim more shelf than you would have been able to have individually if you'd all acted individually. I think that was a break that had to be applied. But so I think it was it was a very efficient, perhaps, way of going. But again, I think it showed the strength of Article 76, or the strength of the Commission process to control. And it was not allowed, that agreement among the 4 was not allowed to modify, the rules of the game, to gain an advantage that's not there through the rigor of Article 76. So that's one interesting case, and there hasn't been all that many joint submissions.
Okay, we have another, maybe a comment rather than a question from Ekaterina Antigia, saying that Russia filed revised submission on February 14th, 2023, and in fact agreed with the conclusions of the CLCS that Gakoris is not an extended continental shelf.
Oh, okay, there we go. Sorry, thank you, Ekaterina, thank you. So my Russian's not able to read the executive summary, so fantastic. So Russia pulling back, and so that's probably what Professor van der Zwag was trying to get to alert me to, the fact. So thank you very much to you both.
We have actually several questions now. One is a very interesting question, and it's again a question from Ekaterina, and she's asking, do you think that if the US submits their data on their limits of the continental shelf to the CLCS, would their submission be accepted or qualified? Or
well, I don't doubt that Ekaterina has some good questions, because of course she's written some wonderful papers and is the real expert. I tend to see the continental shelf as one of these disputes around boundaries. Do you see? I'm not like David van der Zwag or Ekaterina, a continental shelf expert, but this is one where I actually felt like, so I've been reading, and I think I've been convinced that why shouldn't the process be open to the United States? We all win, all the coastal states win. There's predictability again. It's the recommendations will help to really set the stage for this eventual political negotiation. My concern to Katerina and everyone else is that why would the United States do it? Like I'm actually hoping that it stays on course, that there is this will to, they'd be even behind Canada in the queue. So we're talking, 2 decades. And that's my concern at this point, because if the United States, depending who's making the decisions, decides no, will publish. They've been really, really transparent and very much participating in Article 76, absolutely. And the research is based on Article 76, and they're going to publish their findings, and it's going to be transparent. But why would they actually go through the commission process and go through those delays? But if they don't, I'm a little worried about how that might affect the dynamic. Well, they're just going ahead and doing it. So that's more my concern. Thank you for the question.
Okay, thank you very much. We do still have questions, but I think our time is up. So I would like to thank Professor Lalonde for the very excellent keynote presentation. And I think you did refer to sort of the overall situation as dire, but just coming from a region of the world where everyone is blocking everyone's submissions, I think it is still encouraging to see that at the very sort of bottom minimum level, the rule of law is actually working. And I think it's very important. Yes. So thank you. Thank you very much.